The questions relating to Hong Kong are very troublesome, not only, of course, to the United States, but also to the UK and European community. And they raise some disturbing issues about what is an agreement worth that I mentioned earlier this morning. And what is the PRC attitude toward interpreting agreements? And we're very lucky to have Alvin Chung here. He's been here for several years. He's been a young barrister. He's now working on his doctoral dissertation at NYU. He's become an active participant in the American debates, and not just American, with respect to Hong Kong. And he's an interesting, feisty, imaginative person. So, Alvin, we're really glad you're here. And after you make your introduction, I may make a few comments, and then we'll have a discussion. And we have 1 hour total. Yeah. And you're using slides.
I am.
Yeah.
Thank you very much for the effusive introduction, Jerry, and thank you for coming. What I thought I'd do today is not an exhaustive study of the ways in which the Sino-British Joint Declaration has been breached. It's been 20 years. There have been a fair few breaches. We could be here all day. Instead, what I'm going to do is give an overview of some of the key areas where the Joint Declaration has been attacked. So let's start with, well, appropriately enough, the beginning, when the Joint Declaration was signed. And on that occasion, Deng Xiaoping said this: "Some people are worried whether China will abide by the agreement once it has been signed. Your Excellency," referring to then Prime Minister Margaret Thatcher, "and the other British friends present here and people all over the world may be sure that China will always keep its promises." 20-odd years later, the Chinese Foreign Ministry was saying something very different. This is what the spokesperson said on June the 30th of this year. Hong Kong's return to the motherland for 20 years, the Sino-British Joint Declaration as a historical document no longer has any realistic meaning. It also does not have any binding power on how the Chinese central government administers Hong Kong. Two very different stories there. So how did we get from 1984 to 2017? Well, Beijing's chipped away at the Joint Declaration in a couple of different ways, and the way I'll structure this presentation is say a bit about the key provisions of the Joint Declaration, a bit about how the Joint Declaration has been attacked, and finally, I'll say a bit about what the United Kingdom, as the other party to the Joint Declaration, has or has not been saying. So turning now to the instrument itself, it all looked quite good to begin with. We see a number of basic policies, as they were described, in Article 3. Among them, a high degree of autonomy, except in foreign and defense affairs, independent judicial power for the Hong Kong Special Administrative Region, with laws to remain basically unchanged. Article 3, paragraph 5, contains a whole laundry list of civil liberties that were to be protected by law. And Article 3, paragraph 12 said that the basic policies, that is, what was contained in Article 3 and in Annex 1 to the Joint Declaration, were to be set out in a document called the Basic Law, and they will remain unchanged for 50 years. Further on in the Joint Declaration, we see that both the UK and the People's Republic of China agreed to implement the preceding declarations and the annexes to this joint declaration, and that this joint declaration and its annexes shall be equally binding. Things didn't quite turn out that way. So let's look first at the micro level, at some of the enumerated rights. Freedom of the person. Rights and freedoms, including those of the person, of speech, of the press, so on and so forth, shall be ensured by law. That didn't do much good for Li Bo, who was one of the 5 Causeway Bay booksellers abducted by Chinese authorities over their publication and sale of a host of, I'm told, not very good pot boilers on the Chinese leadership. Gui Minhai, who was a Swedish national, was abducted from Thailand. Li Bo, who was a British national, was abducted from Hong Kong soil. Under Article 22 of the Basic Law, mainland government agents are not supposed to operate in Hong Kong territory. When they do get permission to operate in Hong Kong territory, they are supposed to be bound by Hong Kong law. Li's abduction clearly didn't play by any of those rules. Someone decided, you know what? Somebody in Beijing is going to be embarrassed. We're going to ignore all of this. We're going to pick up this guy, bundle him up into a sack, take him across the border, have him confess to various things on television, on state television, and then unceremoniously dump him back across the border where he subsequently refuses to talk to anybody. And you'll see there a report by PEN America, Writing on the Wall, which I had a small part in preparing, which documents the abductions and subsequent ill treatment of the Causeway Bay Five in more detail. Gui Minhai, of course, has now been quote-unquote released, although he's not really free to write, speak, or do anything associated with not being in detention. Freedom of expression I've already touched upon, but a particularly notorious example has been the spate of arguments over whether or not members of the Hong Kong public can even say these simple words: Hong Kong should be independent. Secretary for Justice Rim-Ski-Yun has been adamant that saying those simple words violates the Basic Law, Hong Kong's constitutional instrument, and is criminal. Oddly enough, he has had a great deal of trouble identifying which ordinances saying Hong Kong should be independent has violated. Now, one would have thought that in a society governed by the rule of law, you should be able to identify these specific provisions or charges upon which the prosecution is relying. And that was a point that Grenville Cross, the former director of public prosecutions, took up. And you see there a quotation from him saying that advocating Hong Kong independence in a peaceful way is protected by the Bill of Rights. And that must be correct. It's all very well for Rim-Ski-Yun to say, oh, well, saying Hong Kong should be independent is inconsistent with the Basic Law. Of course it is. The issue is whether or not it is a criminal offense and whether or not it is protected expression. Imagine arguing that gay marriage, for instance, was contrary to the Constitution before Windsor was decided. The notion just seems mildly ridiculous. There are many, many more examples I could raise, some of them related to the umbrella movement protests of 2014. But since time is against me, I'm going to move on now to the next level, scope of autonomy. Hong Kong was guaranteed a high degree of autonomy, except in foreign affairs and defense. What we have seen instead is a host of incidents in which mainland officials, either based in Beijing or in the central government's liaison office in Hong Kong, have sought to meddle in school curricula, the domestic legislative process, the way in which Hong Kong's chief executive is selected, and, as we saw with the denial of entry to Benedict Rogers, immigration. On curricula, It's not just the trifling things either. It's things like what should and shouldn't go into Chinese history textbooks. We have heard a person in the Education Bureau, in fact, the Education Secretary himself, say, no doubt under considerable prodding, that the massacre of June 4th, 1989 and the 1967 communist riots are too trivial to include in history curricula. Something's not quite right here. And then there is another much more troubling case, but one that's much less discussed outside of Hong Kong, and that is the express rail terminus that will be built in Hong Kong and connected to the national high-speed rail network. And what the Hong Kong government wants to do is set up an immigration checkpoint for the mainland authorities in Hong Kong soil. The way they want to do this is to declare certain parts of the terminus to no longer be Hong Kong territory. And therefore they'll be part of the mainland, and therefore mainland laws will apply. Think about that for a minute. What sort of precedent is that setting? If you can arbitrarily declare a part of Hong Kong's territory to be mainland China and have all of mainland law apply to it at a stroke. It's not just going to be the express rail terminus if that plan is approved. What about another hot potato, independent judicial power? Well, what we've seen are three major trends. One, we've seen quite a lot of race-baiting rhetoric aimed at quote-unquote foreign judges. Now, many of these are non-permanent judges sitting on the Court of Final Appeal. Many of them come from the UK, some have come from elsewhere in the Commonwealth. But we've also seen this in lower courts with judges who are not of ethnic Chinese descent, who had the misfortune to get cases that were, shall we say, politically sensitive, and decided them in a way that the government didn't like. Second, the most recent interpretation of the Basic Law by the National People's Congress Standing Committee relating to the taking of legislative oaths was A, politically motivated, and those are not my words, those are the words of the former Secretary for Justice, and B, they were deliberately given in order to preempt ongoing litigation before a Hong Kong court. Again, you're short-circuiting litigation in Hong Kong that might not go the way you want. What sort of message are you sending? And third, we've seen, as we saw with the State Council's white paper of 2014, references to judges being administrators of whom political loyalty is expected. In other words, they have to take national interests into account when deciding cases. So you can forget about any sort of judicial review, you can forget about any sort of challenges to the government through judicial channels. That's not looking so good. But so far, all I've done is talk about isolated rights, chipping away at the scope of autonomy. You know, that can all still be hand-waved away. You can still say, oh, well, that's just the edges. Would that that were the case, because what Beijing has also done over the past few years is attack the notion that the Joint Declaration is binding at all. And they've done this primarily in two ways. One, they've said, well, the Joint Declaration has fulfilled its purpose. It lapsed in 1997. Once the Union flag went down and the 5 stars went up, that was it. The second argument they've made is that the operative parts of the Joint Declaration, namely Article 3 and Annex 1, where the basic policies are set out, were unilateral. And so they were never binding anyway. And if you look back at the provisions of the Joint Declaration, you will see as clear as day that neither of these arguments holds up. This hasn't stopped Beijing or indeed Hong Kong officials from making them anyway. In 2014, in response to the UK House of Commons Foreign Affairs Committee's inquiry, Sir Richard Ottaway, who was then chairman of the committee, was told in no uncertain terms that the Joint Declaration is now void and only cover the period from the signing in 1984 until the handover in 1997. Well, that's a very odd interpretation of shall remain unchanged for 50 years, isn't it? And we saw that again with one of the quotes that I opened with. But it's not just Beijing. We've seen this argument taken up by Hong Kong government officials as well. Now, this is a rather lengthy extract from the Mingpao, one of the newspapers of record in Hong Kong. And it refers to a statement by then Secretary for Constitutional and Mainland Affairs, Raymond Tam. And he said, in essence, as you can see from the part highlighted in red, that the main part of the Joint Declaration has already been fulfilled and has finished and has completed its objectives. He actually goes on to say there as well that the reference to Article 3 and being unchanged for 50 years was a unilateral declaration. So actually we have a twofer here. So which one is it? He can't even get his story straight. Is it that Article 3 was never binding in the first place? Or is it that once the handover happened on 1st of July 1997, Beijing could wash its hands of the whole thing? He's not sure which story to advance, and neither, it turns out, is the Foreign Ministry. Because a few days after making the statement which I referred to at the beginning, we see this. Beijing conceded that the Joint Declaration was legally binding, but insisted it didn't give Britain the right to interfere in the city's affairs. Well, that's a very odd interpretation. This contract is binding, except that the other party to the contract can't enforce the contract. That's what that amounts to. And we see again, China's basic Hong Kong policies were unilateral. Well, that is a very creative interpretation, which amounts to striking out both Article 7 and Article 8. Now, I'm going to arguably go beyond my remit here and say that this is part of a pattern of broader contempt for public international law in respect of Hong Kong. Hong Kong was, well, up for review by the Committee Against Torture within the past year or two, if memory serves, and it was quite strongly criticized for, amongst other things, its ill treatment of protesters during the Umbrella Movement. The response of the Hong Kong government was quite an unusual one. It was to threaten to withdraw from the Convention Against Torture. Hong Kong was criticized by a treaty body and therefore threatened to pull out of the Convention Against Torture. Now, if the Hong Kong government keeps that sort of attitude up, the upcoming ICCPR review next year will be quite an interesting affair indeed. So, faced with some pretty serious instances of breach, what have the British been saying? Well, not very much. Here's what Margaret Thatcher said shortly after the Joint Declaration was signed. I believe that the agreement is a good one. It provides in considerable detail and in binding form for the maintenance of those things which are essential to your unique society. As a result, the people of Hong Kong can, I believe, face the future with confidence. And that was pretty much the same tone we saw in 2017. After a whole host of 6 monthly reports by successive foreign secretaries. And perhaps the most critical thing we've seen is from the most recent report, which included the passage, "We cannot ignore that important areas of the one country, two systems framework are coming under increasing pressure." Unfortunately, the author's Boris Johnson, who A, has some other preoccupations of his own right now, and B, has something of a reputation in British and European politics. So don't look for that to be taken terribly seriously. So perhaps the public service broadcaster RTHK put it best in an episode of the documentary series Hong Kong Connection that aired in 1989, weeks after the massacre. It declared, "China is not credible. and the United Kingdom is not reliable. And that seems to me to be quite a good summary of where we're at with the Joint Declaration and Hong Kong.
That was a wonderful analysis, but I wonder whether you could say something about two aspects. One is Hong Kong not only unsafe for publishers and human rights activists and others who are exercising freedom of speech in the non-business, non-economic context, but what about business people's rights? The publisher you mentioned was in the publishing business. Publishing business directly involves speech. But what if you're in other transactions and you think you're safe in Hong Kong, either because you're a foreigner or because you feel as a Chinese national, Hong Kong is different in its legal system from the mainland? Do we have instances where we should be worrying, in other words, about the human rights of ordinary business people or high-level politically connected business people? What's your thought about that?
Well, in terms of politically connected business people, we've had one who was abducted from the Four Seasons Hotel. And we are supposed to believe that he left voluntarily, presumably just like Li Bo and Gui Minhai and all the others. But on a more prosaic level, we do see instances where the mainland authorities are very keen to stress that certain types of cases are very important, and they have done this in written submissions to Hong Kong courts. This has come up in the context of immunity, not just of PRC governmental entities, but also foreign states. And the two cases I'm referring to here, one of them is called FG Hemisphere, and that was about a vulture fund trying to get its hold on money that a China Rail subsidiary was going to invest in the Democratic Republic of the Congo. The Foreign Ministry repeatedly sought to intervene in the case, and it eventually went up to the National People's Congress Standing Committee. That is the first and indeed only instance in which an interpretation has been delivered at the request of a Hong Kong court. The other case that is somewhat concerning is a case called the Hua Tianlong, which is about a company that hired a crane barge that happened to be owned by a PRC state-owned enterprise. The barge didn't show up. The company tried to sue in Hong Kong court, and the response was, well, you can't, because we are an emanation of the mainland government, and we are therefore immune from suit. The response, the judgment in that particular case said, in principle, that is correct. But on the facts of that particular case, the defendant had waived their immunity. So in response to that, I know of at least one major law firm that issued a client advisory to the effect of, if you're dealing in any way with sovereign debt or state-owned enterprises, you may not want to sue in Hong Kong. That's a serious problem. If your alternatives are, let's say, arbitration with CTAC, which has faced its own host of issues over the past few years, or perhaps no enforcement at all.
What would you think about the potential involvement of the Hong Kong government, especially its police, in these kidnappings that have been boldly performed in Hong Kong? Do we infer inevitably that they couldn't have been done without the cooperation of the Hong Kong police and especially the immigration and customs authorities?
It's hard to say whether the authorities were privy to the planning of the abductions. And that's probably quite deliberate, because the other part of it is no matter what the Hong Kong police or immigration did or didn't do before the abductions, they certainly haven't been very keen to follow up or investigate. And we've seen over the past few years a consistent pattern of the police turning a blind eye to numerous alleged offenses when they're committed by pro-Beijing actors. But the same is quite clearly not true for anybody who has different political leanings.
A more, you might say, publicized problem, and it's surprising that you haven't yet mentioned it, is what about the prosecution of Joshua Wong and Nathan Law and some of these other people? Where does that fit in? Is that inconsistent with the basic law, or is it a good example of fair justice in Hong Kong and judicial independence? That's been mooted around so much. It'd be good to have your view.
Well, to some extent, I think judicial independence is a red herring. And there have been quite a few commentators, including the New York Times and any number of others, who have been fairly quick to beat up on the Hong Kong judiciary. Now, to be fair, Wally Yeung, the vice president of the Court of Appeal, who wrote the judgment, is not, it would be fair to say, the finest jurist on the Hong Kong bench. And his statements in the appeal that led to Joshua's and Alex Chow's and Nathan Law's incarceration was quite clearly inappropriate. But the much bigger problem, which Jerry's alluded to, is partisan prosecutions.
Why don't you tell us briefly the facts of the case, because a lot of people are not familiar with them.
So the prosecutions involved the initial attempt by student protesters to enter Civic Square, which is the forecourt to Hong Kong government headquarters that had been sealed off and surrounded by high fences. They were initially prosecuted, they were given community service, they'd finished serving their community service, and then the Department of Justice demanded that their cases be reopened for resentencing. They went before a court of appeal, led, as I said, by Vice President Wally Yeung, and they were subsequently sentenced again, this time to imprisonment.
So the first trial at the lowest court resulted in a tap on the wrist called community service. What does that mean?
Community service, it's largely what it says on the tin. You are directed to do things like empty trash cans, sweep streets, and so on.
No confinement.
There is no confinement involved.
And these people did their community service.
They completed their sentences.
And at that point, the Secretary for Justice decided that was not satisfactory, and the case should be appealed for a harsher sentence.
Indeed. And what is particularly striking is that the Secretary for Justice, Rim-Ski-Yun, demanded that the case be reopened despite the advice of his own senior career prosecutors. They were against reopening the case. He went ahead anyway. That is, to say the least, very, very unusual. And there is a quotation from a former Peruvian president that I think sums up the situation quite well. For my friends, everything. For my enemies, the law. And that is what we are seeing in Hong Kong today.
And what did the Court of Appeal decide in terms of punishment?
Sentences were on the order of several months, which, in addition to the mere fact of incarceration, would have disqualified all three of them, Joshua Wong, Nathan Law, and Alex Chow, from public office for 5 years.
And after they received such a sentence, what happened?
The three have appealed. Joshua Wong and Nathan Law were subsequently let out on bail, and their case will be heard by the Court of Final Appeal tomorrow, well, later today, really, the 7th. In fact, and I was just told this morning, two of the UN special rapporteurs, one on freedom of expression and one on human rights defenders, have issued a joint statement expressing their concern about the imminent appeal and calling for the rights of the three appellants to be respected.
What annoyed me about the case was once the Court of Appeal decided against them, they were not given bail, but the system seems to involve keeping them in jail for a few weeks until they can properly apply to the Court of Final Appeal, and the Court of Final Appeal has to then decide whether they should be given bail. That means someone who has a significant case spends time in prison in circumstances where in this country you would get a bail decision very quickly. I take it this is just an accepted part of Hong Kong justice.
Accepted may be putting it a bit too strongly, but that is certainly how criminal appeals, the Court of Final Appeal, work, as I understand it.
Well, now Joshua is out and awaiting a chance for a hearing. What do you estimate the chances are?
Frankly, I am not very optimistic. It is possible that the Court of Final Appeal will conclude that the Court of Appeal went beyond its remit in reopening issues of fact and deciding them on its own. But my concern with that would be whether or not that would draw a subsequent interpretation or pressure for an interpretation. My own intuition, although my practice was not a criminal law practice, is that they may get a jail sentence of some kind. Whether it will be one that disqualifies them from elective office, I don't know.
Does this involve any question of violation of the joint declaration between the UK and the PRC?
It does, insofar as it implicates, of course, the freedom of expression and the freedom to demonstrate, both of which are referred to in the Joint Declaration and also in the International Covenant on Civil and Political Rights, which Annex 1 also says shall remain in force in relation to Hong Kong. So that will probably come up at the upcoming review next year.
I was upset, of course, by the statements of the Chinese Foreign Ministry that they gradually seemed to backtrack on, that were another example of China just saying, we no longer feel bound by an agreement we made in a very solemn circumstance. Well, we have other questions, as you mentioned, with respect to education, including legal education, including even at the primary levels in Hong Kong. But let's open it to discussion here. Anyone want to say something? Yes, Bill Kaiser. Bill is a veteran journalist who's spent a lot of time in the Greater China area.
I'm wondering if you might comment on another high-profile case that came up some time ago, which was the transshipment of some military equipment which had been used in training in Taiwan, and while it was in Hong Kong, that shipment was held by the Hong Kong Customs Authority. And it's probably a reaction to China's position about Singapore, being that those military vehicles that were being shipped belonged to the Singapore government. At that point, Singapore had taken a rather tough position towards China on the South China Sea issues. What do you think that says about Hong Kong's free trade position?
It doesn't say very good things. And this goes back to Jerry's point about, well, should ordinary business people be concerned? And the Hong Kong government's been very keen to say, oh, we have rule of law, we're open for business, come and invest with us. Well, that's all very well and good until suddenly it isn't. And so we saw that with the arms shipments of I think it was Terex military vehicles. We also see this, oddly enough, with the company's registry. Now, there is no specific legislation governing political parties in Hong Kong, so they have to incorporate in order to raise funds. But certain political parties have found that companies' registry applications, which are normally dealt with in a matter of weeks, have been sat on for well over a year. Some of them are finding that all of a sudden they're not being allowed to operate market stalls during Lunar New Year's for quote-unquote public safety reasons. So, you know, the Hong Kong government's been trying very hard to look like, oh, we're a free port, we're open for business, we're all very friendly, look at how well we do in the rule of law league tables. But really, if you scratch a little deeper, you find that it doesn't quite hold up.
In that case, as I remember it, Singapore had used Taiwan as an area for training its troops in some respects. And the interference with the transfer of this equipment seemed to be a retaliation against Singapore, interfering with its receipt of this equipment. And that suggests, again, a very political motive. I'm always curious about Singapore-mainland relations seem not to be very good lately. I think it has something to do with a later subject we'll talk about, South China Sea, but I think it has to do with other things also. Other comments here? I'm trying to get people who haven't yet spoken. Yes, please.
Okay, thank you, Professor. I have a series of very simple Chinese questions. Since our topic is China and international law here, and I wonder, you just mentioned that based on the Chinese government's conduct and the UK's non-response to such things, I wonder, the first question is, what do you think is the nature of the Sino-British Joint Declaration under the very basic principle of international law level? And you just, maybe, if I understand you correctly, you mean that it is not like what the Chinese government say, it is not a unilateral declaration, it may be an agreement between two sovereign states. And my next question is, if so, to whom will Chinese government owe such obligations to? To whom will the Chinese government owe such obligation? And who has a right to interpret such joint declaration? And what if Chinese government did breach or default? What would be the
Joint Declaration is a bilateral treaty. It was duly registered with the United Nations in 1985. You can look it up in the United Nations Treaty Series. And as a bilateral treaty, the counterparty to whom obligations are owed is the United Kingdom government in Whitehall. Any more questions?
If you think the UK government did not respond, then is there any other available remedies?
There are, of course, more indirect channels. I've already referred to some, such as the statement by the two UN special rapporteurs. There are periodic reviews by treaty bodies in respect of agreements such as the Convention Against Torture and the ICCPR. I understand that a new NGO has been set up in the UK by Benedict Rogers called Hong Kong Watch, which is devoted to these issues. And if you are interested in them, I would suggest following developments there closely.
Okay, thank you.
So what should the UK have done in order to try to protest what it deemed a blatant violation of China's obligation under the treaty? Could it have gone to some adjudicative body, some mediating body? Could it have applied economic sanctions? It could have obviously made a much bigger fuss about the whole thing, and right starting at the prime minister level. But is there much that can be done? And why didn't the UK do more?
Starting with why didn't the UK do more? And part of it, I think, frankly, is a very cynical reason. And in fact, Hong Kong Connection, the documentary I referred to, addresses this in part. It was about the demand by Hong Kong residents for right of abode in the UK after the Tiananmen Square massacre. And the response was essentially, no will be flooded with Hong Kong residents, you can't have right of abode. The UK essentially wanted an agreement that looked reasonably good as long as nobody held it up to too much scrutiny, and then washed its hands of the whole thing after 97. What other mechanisms has the UK tried? Not very many, but here's one particularly interesting development from about 1996, when the Beijing government decided that the members of the Legislative Council in Hong Kong at the time would not get to hold their seats after 97. Instead, there would be a new provisional legislature, which of course was heavily packed, until fresh elections could be called. And in response, then Foreign Secretary Rifkind threatened to take the matter to the International Court of Justice. China does not accept ICJ compulsory jurisdiction, and the then foreign minister said quite bluntly that it was, quote, futile to play the international card, unquote. So I think there were some pretty heavy hints pretty early on that, had a British government been so inclined, would have warranted a stronger level of retaliation in some other way.
The joint declaration and I think the basic law, you'll have to check me on that, refer to the protections that the people of Hong Kong would enjoy under the International Covenant for Civil and Political Rights.
Yeah.
Does that offer possibilities? Of course, Beijing, while it signed that covenant, has never ratified it. But Hong Kong was supposed to continue to have the benefits of that. And is that relevant or helpful in some way?
It has helped to a very limited degree, but really, if the only thing that the people of Hong Kong can rely on is treaty body review every few years, then that isn't exactly very reassuring. And for its own part, the Constitutional and Mainland Affairs Bureau which handles the treaty body reviews, has not, on the whole, been very enthusiastic about soliciting involvement from local NGOs, as I understand it. So there is some utility in treaty body review, but it really doesn't do quite enough.
But what about the courts? In theory, it would be possible, wouldn't it, to invoke the assistance of the courts? But I gather that hasn't proved effective.
The use of the Hong Kong courts has, again, some pretty clear limitations. Things like caseload or how long it takes or how much it costs on a pragmatic level. But we're also seeing an increasing degree of pushback by pro-Beijing politicians. The former chief executive, C.Y. Leung, was notoriously hostile to judicial review of any sort. Recently, there's been a proposal by a quote-unquote think tank, which I suspect is really more of a gongo, to the effect that anybody who applies for judicial review should pay much higher filing fees and impose and be subject to a whole host of conditions that make judicial review essentially next to impossible to get or apply for. So again, there are very serious political pressures on that mechanism as well.
Questions? I've got more, but I saw that. Are you still questioning her or no?
Well, so you asked my question, but I guess I can do a follow-up question. Excuse me. In terms of the mechanisms to, I guess, put pressure on the Chinese government to, respect the ICCPR rights protection in Hong Kong, I do think the ICCPR and other human rights treaties are a good entry point for the outside world, the international community, to really pay more attention to Hong Kong's situation and to put more pressure. Because, you talked about the UK, it's not doing more, and it seems that all the attention is on the UK in terms of its role in the joint declaration. But I do think, broader than that, the outside world should care about Hong Kong from the perspective of protecting international human rights.
Tony?
First question is, what is the beginning of the end of one country, two system? The abduction of Li Bo, or the arrest of Joshua Wong, or the Umbrella Revolution, or the white paper in 2014, or the August 31st, the National People's Congress interpretation. And second question is, in 1997, as far as I understand, the vast majority of Hong Kong people welcomed the returning back to China, which remained a brutal dictatorship, and it was only 8 years after the Tiananmen massacre. And 20 years later, so what was the role of patriotism or the nationalism sentiment in Hong Kong-China relation? In other words, what kind of change of identity of Hong Kong people, given the fact that more and more young people are in favor of Hong Kong independence?
The state of one country, two systems. I wouldn't say it's completely dead. I would say it's on life support. and of course, the issue that there is, the Hong Kong government can sort of hand wave away these X, Y, and Z as, these were isolated incidents. Well, it's like Springer Nature blocking less than 1% of the articles on its database in mainland China. Not all articles are equal. Some are more important than others. It may be that 0.1% that really counts. And I think that's exactly what we're seeing with Hong Kong. We're seeing that Beijing will tear up the joint declaration when it really counts. Public sentiment and Hong Kong identity. Well, the national anthem law, which upped the sentence for disrespecting the national anthem from a number of weeks to up to 3 years in jail, was directed primarily at Hong Kong soccer fans. So that kind of gives you some measure of what the public sentiment is. Does that mean that a majority of Hong Kongers endorse independence? Absolutely not. Does that mean that a substantial plurality of Hong Kongers feel like the bargain that was originally promised to them hasn't been kept? Absolutely it does. And that there is a meaningful difference between these two ideas that Beijing has consistently tried to blur. And in fact, I'm sad to say that a former colleague of mine, Wang Liwen, has written in an article that was widely shared in Hong Kong that even advocating modest defenses of democracy and Hong Kong autonomy is in fact stealth advocacy for independence. So that's the kind of political climate that Hong Kongers are reacting against. I just wanted to say something briefly about Yujie's comment on international pressure. And I would say this. Beijing has been largely, though, as we've seen, not entirely impervious to that sort of international criticism. But the Hong Kong government is terrified of it. We've seen, for instance, in the wake of the resentencings of Joshua and company, that the Hong Kong government has been very quick to issue vehement denials that the rule of law in Hong Kong is under threat in any way. This was all done in accordance with law. And so that, to me, would seem to be the more appropriate pressure point.
That's interesting. Yes, Peter Dutton, there you are.
Yeah, thank you. Alvin, thanks. This is a terrific presentation. I'd like to revisit a point you made earlier, which has to do with the UK as the beneficiary of the treaty. Isn't there some room for considering the people of Hong Kong as third-party beneficiaries of the treaty, having some standing independent of the UK?
As a matter of straightforward treaty interpretation, that's a pretty difficult one to argue. And if you look at the historical background to the joint declaration, in fact, Beijing tried very, very, very hard to keep anybody who might be said to represent Hong Kong out of the negotiations. Sir Edward Youd was governor of Hong Kong at the time. When he said, "I represent the people of Hong Kong," Beijing said, "No, you don't, or you're not showing up at all." The one sort of token reference to that is, oddly enough, in the same speech by Deng, where he says that any arrangement regarding the future of Hong Kong must be acceptable to all three parties, and that clearly includes the people of Hong Kong. So as a matter of strict treaty interpretation, I don't see much scope for argument there. I would hinge it more on treaty interpretation of the human rights instruments rather than the joint declaration itself.
How are judges treated in Hong Kong? I felt when some of the people I generally agree with said Joshua Wong's conviction shows there's no judicial independence. And the Bar Association, by the way, seemed to say there is judicial independence. How do you explain this contradiction? Is it a case of the Bar Association, which often will dispute authoritative government views? It went to bat on the government position because we were focusing on the wrong thing, that the question really isn't somebody trying to call up a judge and telling him what to do, but the judge himself, in a free exercise, supposedly, of his discretion, makes a pro-government decision. What does that tell us about the state of judging in Hong Kong? Do judges get promoted? Who decides how they get promoted? What other factors? We would know what influences judges here, but can you tell us a little bit about the judicial context?
I think the criticisms of judicial independence of Hong Kong have said a great more about the people making the criticisms than they have about the state of the judiciary. Now, that is not to say that there are not potential pain points. For instance, Mr. Justice Bukhari, who was on the Court of Final Appeal, didn't have his term renewed after he reached retirement age. Now, it is normal for permanent judges on that court to have their terms renewed at least once after they reach statutory retirement age. So there was a hint there that something fishy was going on.
What was about him? What was his reputation?
He had a reputation for being an outspoken critic of the government in his judgments. And he was replaced, I understand, by somebody who was in fact older. So age couldn't have been the factor that led to his non-renewal. In terms of appointments and promotions, there is a statutory body called the Judicial Officers Recommendation Commission. It is supposed to be an independent statutory body. However, many of its members are chosen either directly or indirectly by the chief executive. So if somebody were inclined, for instance, to try and pack the courts, there would be an easy way to do so. Other issues include, judicial caseload. And so what happens there is that the government hires deputy judges who sit part-time, or they get retired judges to come back. But these deputy judges don't have security of tenure. So that's another underlying issue. But the emphasis in almost all of the commentary I've seen is a much more straightforward, there has been telephone justice here, which distracts from and frankly cheapens the whole debate about judicial independence in a way that I don't think is helpful.
I remember when the joint declaration was announced, a leading Hong Kong journalist from the South China Morning Post came to interview me. I was then practicing law in Hong Kong. And he said, now that we have this document, all the problems of Hong Kong's future are solved. And I said, I think you got it wrong. I said, now that we have this document, that's the beginning of a struggle to see what do its words mean. It has to be interpreted. And we had a famous judge who once said the words of the Constitution are empty vessels. And it was the Supreme Court that poured meaning into them. Now, when the Basic Law was enacted after the Joint Declaration, they appointed a committee, the Basic Law Committee, that was supposed to be an interpretive body. 5 people, I think, from Hong Kong and 5 from the mainland. Isn't that right? And 2 of the 5 from Hong Kong were real legal experts. Albert Chun and Tony Leung, what's his name?
Tony Neo.
Neo is a Hong Kong pronunciation. And these are really high-powered people. And I thought this Basic Law Committee conceivably could become a real final court of appeal from which questionable Hong Kong cases could be reviewed, just the way you had a provision under colonial Hong Kong to go to the Privy Council Judicial Committee in London, and you had serious legal argument about what does this provision mean in the Basic Law. But the Basic Law Committee, it seemed to me, never went that way. It became a political committee rather than a legal committee. I once suggested to the first chief executive of the Hong Kong Special Administrative Region that they have argument and turn it into something the people in Hong Kong could respect as a serious, impartial interpretation of what do these guarantees mean. And he said, oh, that would just mean that Martin Lee and all these other human rights lawyers in Hong Kong would come and make more fuss and more trouble. So instead, this committee has never amounted to anything. It could have instructed the National People's Congress Standing Committee on what the proper interpretation of law should be. And I felt that was a genuinely lost opportunity. Any final remarks? We have to end now.
Well, a lost opportunity seems to be pretty much an accurate description of the entire instrument at this point.
Well, I'm sorry that we have to depress our audience with another discussion, but maybe the next topic will be more encouraging, because we now have to look at Japan's view on some very controversial international legal questions. But thank you very much, Alvin. That was very good.